everyone. Happy Monday. I am Christina Malyan from Malyan Law, and I am here today, Monday, June 1st, with a landlord-tenant attorney. First and foremost, I want to wish and tell everybody, I hope everybody's safe and sound and protected. I know there's a lot going on in the world, and especially in California. So with that said, we hope that this program could be educational, informative. If you're a landlord or tenant, this is definitely something you want to tune into and be able to share with your fellow tenants or fellow landlords. Tonight's program is going to be heavily focused on that. So if you tune in and share this program on your feed, you can ask us any questions, and Alex and I will try to answer it. With that said, I know a lot is going on with businesses and buildings being burned down and vandalized. So therefore, I'll be providing some coverage on that later this week on another live program that I'm going to put together last minute. My former programs have focused on PPP, fraud, applications, bankruptcy, debt settlement, employment. So I hope to bring these to your attention as the days go on. Without further ado, tonight we have Alex, and I will have him introduce himself. But Alex comes from an extensive history of practicing in different areas, starting with insurance defense, moving on to business litigation and real estate, and currently heavily dominating in the real estate practice area with some landlord tenant. And he's taken the time on this Monday night to come and join us and hopefully provide some guidance to our followers. Hi, Alex. Can you please introduce yourself? Let us know where, which firm you're from, and, a little bit about your background.
Thank you, Christina, and thank you for having me tonight. It's been great getting to know you over the last few weeks and sharing resources and just talking shop as lawyers do. My name is Alex Kasendorf. I am a partner at the law firm of Albert, Barr & Grant. We're located in Encino, right across the street from Birmingham High School, at the corner of Victory and Balboa. I've been practicing since 2001. Seems like a long time.
Oh, wow.
Sometimes feels like a long time. And I've been at my current firm now for almost 12 years, since 2008. And as mentioned, I'm a partner at the firm. Our firm handles all sorts of business and real estate matters, litigation, transactions. I do some lobbying work, and we do a lot of work in the landlord-tenant space for landlords, for tenants, residential and commercial. And I'm joining you live from my backyard in Van Nuys. So I hear copters and sirens going on. So I want to reiterate both of our hope that everyone is okay and safe and staying positive and moving forward as a community.
Absolutely. And like we mentioned earlier, and hopefully everybody's safe. And I am from home, obviously working, especially after hours. We just want to make sure that everybody's safe. Please ask us any questions. And we're going to dive right into it. Alex, my phone has been blowing up. And with that said, I've been directing almost all my phone calls to you. Landlord tenants, the rights, what they can do, what they cannot. So stay tuned. We will ask all the questions that have come in throughout this whole time and try to address it. And if we need to repeat ourselves, we will. One of the biggest questions, Alex, that is, I think it's mind-boggling, is what are my rights? So could be as a landlord or as a tenant. I want to start with landlords. And then we'll move on to tenants. And I think you're going to touch upon a little bit of both, given the fact that they intertwine. I want us to know, or to tell our viewers, let's begin with when COVID hit, we got orders down from the local government, from the county. We moved up to the chain of state of California. We are in a state of emergency. What orders came in, not the actual law itself, but what is the understanding for on a landlord tenancy basis from these orders?
Sure. So it's very important to understand that the orders, the legislation, the rules that are in effect are different depending on where you live, where you own property, where you rent property. And it can be very confusing. I know I was talking to you yesterday about these emergency curfew orders. Are we in the city? Are we in the county? Is it 6? Is it 5? The message coming from those that are providing the message can be confusing. So
Okay.
the key is to understand what jurisdiction you are in and work from the bottom up. And what I mean from the bottom is start in your city. Okay, you're in Glendale, I'm in technically Los Angeles because I'm in Van Nuys, but that is just a neighborhood of Los Angeles.
Mm-hmm.
So you're in Glendale. It's it's its own city within the county of Los Angeles.
Right.
So in my case, I'd first look at what are the specific rules for the city of Los Angeles, and then work my way up to the county, to the state, and at the federal level. Now, in these cases, the federal rules typically will not apply as much. There are certain rules related to what types of mortgages are held on the property.
Okay.
There are certain rules for larger corporations who own property and things of those lines that typically I don't see in my practice area. But the main one will start right here in Los Angeles. And the mayor, Garcetti, back in, I believe, mid-March, and then over time, the city council passed some different rules as well that dictate what you can and cannot do during our pandemic period regarding landlord-tenant relationships.
Okay. And I know that had like a quote unquote date, maybe not set in stone, but it was May 31st, which was yesterday, correct?
Right. So the trigger date for all of these is the emergency period. When does the emergency period end? Because as we'll get into, that will then determine how long you have to repay rent, how long you have to perhaps file a lawsuit enforcing your rights as a landlord. And that date keeps getting pushed back. It was supposed to be, I think, earlier in May, and then it was today. And bottom line, it's not over yet, and no one seems to know when this emergency period will end. All indications still could be a couple more months at the very least, theoretically.
And to those who are joining in, I know we're getting a lot more people viewing it as I'm actually, when I look down, I'm sharing it to different groups. So we are talking about landlord-tenant rights. We are going to address commercial and residential. They are different, they are similar. So we're going to try to break it down and make it as clear as possible. So like you said, let's dive right into the landlords for residentials, okay?
Sure.
So we got the order as, hey, you don't have to pay your landlord. Is that a true statement? And with that said, what advice would you give on behalf of rent for residential complexes?
So don't tell my landlord friends and clients.
Okay.
We'll have to keep this a secret. But if you're renting property, at least in the city of Los Angeles, you do not have to pay your rent at this point in time.
And I know you're mentioning city of Los Angeles because I work in Glendale, and Glendale's a different entity of its own. So Glendale, like you said earlier, may have its own local rules, correct?
Correct. And so it's always very important, even as lawyers, the first thing that I'll do is make sure I'm sufficiently familiar with whatever rule is in place. I know the city ones very well, but for example, I have a commercial client, a client who owns commercial property in Bakersfield. I had to look up what the rules are in Bakersfield. And to extrapolate that question, the entire state is under basically a no need to pay at this moment. And then the question from there is, well, when do I have to pay it back?
Okay, so the typical thing, we're not saying you should not pay. We're saying you're not required to pay because of the state of emergency. But what happens, Alex? Like as soon as the state of emergency is lifted for residential property tenants, what should they expect, or what should the landlords know when they can collect back rent?
So it again will depend on the jurisdiction, but in Los Angeles, the city has given tenants in a residential setting, which is different than a commercial context, 12 months to repay rent.
Wait a minute, 12 whole months from when it's lifted, right? Like the state of emergency?
Correct. When the emergency order is lifted, whenever that date ends up being, from that date forward, rent will start to accrue is not the right word, because rent is not accruing. It's just not due. So let's say it's July 1, emergency period's over. Okay, so you would have to pay your rent. There's a question as to when you're going to have to pay. Likely within 30 days, pay your rent for that month. But then you'd have 12 months to pay all of the back rent, June, May, April. And theoretically, the question is, depending on when your rent was due in March, folks may have already paid their March rent because this didn't really start until the second or third, or think about March 12th, 13th or so.
Yeah,
But
exactly.
the main takeaway is 12 months to repay any rent that the tenant did not pay. Late fees and interest cannot be included in that. And there is no rule set yet as to how that 12-month repayment has to be made. Do you have to do it 1/12 of the rent payment over 12 months? That I don't know the answer to.
Okay.
But my understanding is you could pay it all back on the last day of that 12th month.
For now. And by the way, for our viewers, you guys all know things are changing as they speak. The world is changing as we're going about it. Every day we're waking up to news. So things can happen. And I know the state of California declared its own state of emergency or the city. So things are happening, and attorneys like Alex and myself, we have to keep up to date. I know there's a lot of questions coming in. I'm going to address the questions. I do want to lock in the residential and commercial rent and late fees before I start asking those particular questions, Alex. We do have a lot of viewers and we are getting a lot of questions. Now, you mentioned a good point. If we're in the state of emergency, the landlord, is it a true statement if I say the landlord does not have the right to charge late fees or interest?
That's correct.
Okay. And when the rent is due, and let's give a hypothetical. Presume that the state of emergency ended today, which it didn't, so don't take our word for it. This is just a hypothetical. Like Alex said, depending on when your March, April, and May payments were due, you have to, Alex, the tenants have to make their current payment, June's payment, and then from this date on, they have 12 months to whatever, understanding or rules come down to make their payments, correct?
Right. The one thing that I'm not clear on is, using your hypothetical, June 1 it ended.
Yeah.
Well, is June's rent due today? I suspect there'll be guidance coming from, at the very least, the state as to when that current period is due. I really can't imagine that our government will say, okay, everyone is out of the house, back to work, we're opened up, no emergency period, and guess what? Your rent is due today or yesterday.
It's policy decisions, right? They're
Correct.
going to make it on basic public policy. Now let's move on to, so if anybody, I had questions and I think we're addressing its questions are, my landlord is tacking on late payments to my accrued rent during the state of emergency because I had a history of making late payments. Is the landlord allowed to do that?
So in this scenario, what I suspect the landlord is going to say is, you were always late. You were always late.
Yeah.
So you're not late because of COVID-19.
Right.
You're late because you're a late pay. That's just who you are. So guess what? I'm going to keep charging you that. Well, guess what? The landlord's not right in that scenario. Whether or not the tenant is typically late does not give the landlord the right to use that as an excuse to tack on late fees during this period. Again, absolutely no late fees or interest during the time period that rent does not have to be paid.
Wow. Okay. Moving on to commercial property. And if there's follow-up questions, I'll ask them. I see a lot of people asking questions. I'll come to you. I want to address commercial. Sure. Commercial landlords, what should they know as to when back rent is due? Because this applies to them as well, right? You don't have to be your commercial landlord right now.
Correct. In the emergency. And the main difference, and there are some nuances, and it may be different per county or jurisdiction. Again, harkening back to my client in Bakersfield, when I investigated some of the local rules for them. But the repayment period is now 3 months, not 12 months. Meaning a commercial tenant.
The huge difference is 12 versus 3.
Knock off 9 months, that's when it's due.
Okay.
So commercial tenants get a little bit of a break, but if their business is shuttered, there's going to have to be a lot of questions and hard questions and answers, and hopefully some good faith negotiations to work these things out.
And we're going to talk about those. We're going to talk about those of how to avoid attorney's fees. Sorry, Alex, but we're here for consumers. And let me see what questions we have coming in. And thank you so much. We have a lot of people joining in. So yes, let's see. Okay, I'm going to scroll back up. There's a lot of people, and I want to talk about, remind me, definitely nuisance and neighbors, being thing. So we have a question. Let me read it out loud. If you need more information, we can definitely ask or have the person reach out to you. So if it's something we don't have answers to, we'll let you know and we'll reach out to you. Somebody asked, I live in a building with amenities. It has all been closed and still are. Why won't our building give us any kind of discount since we are not able to use any of the amenities we technically pay for? We only noticing deferral options. Do you have any comments regarding that?
I've not dealt with this directly, but I did see the question
Yeah.
come in, and I was thinking about it as we were talking. So this is how I envision it. I live in an apartment complex. There is a pool.
Sorry, Alex, I'm going to cut you off. Do you have us going live on your phone?
Yeah, so that's why I'm.
Can you put down the volume? I think it's bleeding into the feed.
Yeah.
Yeah, perfect.
Any better?
Looking at it. Go ahead. Yes, much better. Sorry.
No problem. I was sharing to my groups as well.
Awesome. Thank you.
Sounds like a plane. Oh, we got an LAPD copter flying over Van Nuys.
Coming towards Sun Valley, my house, so we're good.
It's going south, so probably towards
Ventura,
the City Hall area.
Yeah, okay.
So there's a pool. There's maybe a tennis court. It's all locked. You cannot come in.
Yeah.
Well, I suspect the lease itself doesn't say you're paying X for this and Y for that. And the reason is the landlord doesn't want to break down what the amenities are in case you cannot use those amenities. So the question is, should I have to pay, say, $3,000 a month for my unit, but not being able to use amenities which arguably are part of the rent? Arguably, that landlord is charging more than the next door place that doesn't have a pool or a tennis court and is utilizing these amenities to gain interest in the facility, get more tenants, and get more payments. So in this case, I'm unaware of anything in the current rules that say that you're able to deduct your rent payments because of the inability to obtain full value. Now, under normal circumstances, you're paying X, but you're not getting like value. You could sue the landlord for essentially, it wouldn't be a habitability claim, but it would basically be a breach of contract, right?
Like a right of enjoyment.
Well, quiet enjoyment is the general statement that you have the right to a quiet and a comfortable place to live. It would more be along the lines of a straight breach of contract case. And in the case, let's say there's 80 apartment owners, well, someone could fancy up a nice class action lawsuit against that landlord. So the best thing for these tenants to do would be to jointly go to the landlord in a respectful manner, perhaps have a letter signed by all tenants, and ask for a modification to the amounts owed, whether it be amounts already paid or amounts that are accruing during this period, because we're not able to utilize this feature. Now, the problem I see is
if it was like an HOA where the HOA fees are designated for these community areas.
So in that case, and I was actually president of an HOA for 7 years or so. And we didn't have any amenities. We had a sun deck, I think was what we had. But most HOAs do have certain types of things that their HOA fees go to. Now, understand, HOA fees go to oftentimes water usage for the entire building, go to landscaping, perhaps security, insurance, things on those lines. But if the budget states that a portion of those HOA fees were to go to, say, pool maintenance, and I stop myself because the pool may still need to be maintained, but you're not able to use it. So that's a question in an HOA sense.
Use and maintenance are two different things.
Use and maintenance are different. An apartment complex owner, an HOA, may still have to maintain things that their tenants or owners can't use. Also, the question is, should those tenants or homeowners in the HOA get a discount? In the HOA's case, I would just bring it to the next board meeting and say, listen, we have all this money in reserve. We have all this money that we're getting on a monthly basis from each homeowner. We're not able to use this. Can we authorize a reduction in HOA fees for a certain amount of time? HOAs can agree to do whatever they want. It's their money. It's 80 of us paying together versus an apartment complex. It's 80 of us just paying the landlord. So it's a little different, and there's a little bit different in terms of leverage and negotiation tips to handle.
But HOA is made out of comprised of the tenants, correct?
Well,
most situations?
so the answer is yes, but not tenants. So they are
Okay.
owners of typically it's the space. You own the airspace within your four walls. And then you also have rights to use whatever is in that building and perhaps an exclusive easement for your patio, for your parking space. So yeah, you basically jointly own your building and you all pay for the same thing.
Right.
So if you're all putting money into a pot on a monthly basis, the HOA could even say, we're going to freeze HOA payments.
Okay.
But that's up to the HOA because a board has to make a motion and then it can be voted on by the HOA members.
Thank you for that. Let me scroll down and see if we're getting, Ms. Nash said 12 months to pay Regis, right? Yes, 12 months for residential, commercial is 3 months. Isn't it true that the time for repayment of rental also depends on whether the residential landlord has a federally backed mortgage?
Absolutely. And I touched on that, and I'll be upfront. I don't know the answer, but it can be found online. That's one of the examples when we were talking about what levels of jurisdiction you have to look at to determine what rules are in play. There are a couple rules that come from the federal level. And if the property is either owned, I believe it's by a corporation, a certain size corporation, or has some sort of federally backed mortgage, there are different options on what you can and can't do. We actually have a client who has a series of investment properties, and they're trying to work out repayment options on their mortgages because it's not where they live, it's their livelihood, it's their investments. And depending on whether they have either a Freddie or Fannie Mac component will depend on what that is. So in that case, and I'm sorry I don't have the exact answer, Google, federal mortgage assistance for renters, something along those lines, and you'll be able to find information, hopefully in a bullet point, easy to understand language about what impacts there are on property owned with a federally backed mortgage.
Do you think it'll be similar to the ones that are in place, or do you think it might be shorter or longer? Well, what are your thoughts on that?
It may actually be more extensive in the sense of if the local jurisdiction doesn't have, LA is going to be probably at the highest end of repayment terms. There may be less options in other jurisdictions, but I'm thinking the federal option would likely give even more protection. I think. Again, I know I've seen it. I haven't read it in depth because it hasn't applied to any of my clients specifically yet. Okay.
Let me see. Somebody said, and to those who are joining us in right now, we are conducting this program because I know there's a lot going on outside, and hopefully everybody's following the curfew and staying indoors as they should. Give me 1 second. I'm trying to scroll through the questions. And we are talking about landlord tenants because of the fact that it is a hot topic. And it's a very hot topic. Sorry, my Facebook volume went on. We want to bring light to all the questions and everything our offices are dealing with. There's a question that came in that said, can a landlord decide to do a price per square foot adjustment during COVID if tenant is month to month? Let me see where that question went. Speaking commercial property. Okay, so this brings me to my next question, which we'll get into the commercial aspect too. Great question. I know that they cannot collect rent right now during state of emergency. Can a residential landlord actually increase rent during this time?
So I'm going to pause for a second because there's a helicopter seemingly right above my head.
Okay.
Can you hear it on your end?
Somewhat. I'm good.
All right. So rent cannot be raised in a residential setting at this point in time. There's a lawyer who actually posed a question in the Facebook group that we're members of fellow lawyers about there is a exception in the rent control Los Angeles properties about a change in value increase even during this current time. And he was asking, does anyone know anything more about this? It seemed to be an exception in the rules that allowed a landlord to do a rental increase. And the short answer was no one seemed to really know what this was about. That we all saw what it says, and helicopters. Now they're going your way. They're going northeast.
Okay.
But the link just said it has to be approved by, at least in Los Angeles, by the Housing Community Investiture Department, HCID. So it likely has to have some sort of application. But I have to think that absolutely no rental increases will fly during this period.
Is that true for commercial as well?
True for commercial as well. Yeah, there's essentially rent freezes for the time being.
Okay, but wait. During COVID, during state of emergency, you're saying there's a rent freeze for residential? We know for sure. Do we know for sure for commercial as a landlord cannot increase and enter into a new contract for increased rent?
So I'm not aware, sorry if I wasn't clear, I'm not aware of anything changing rental increase freezes in commercial properties.
Okay.
That is, as far as I know, and I was checking with a colleague earlier, that there is no prohibition on increasing rent during this time. Funny, I got a text from a neighbor. What's with the helicopters?
Yeah.
And he lives a few blocks away. So the same prohibitions exist for commercial property owners dealing with eviction, but I'm unaware of any prohibition on raising rent, assuming that lease allows it. Obviously not in the middle of the lease term, but if the lease expires.
Let's say they're month to month for commercial property, and they get into an agreement to increase rent by $1,000. The tenant agrees, they get into a written agreement, and then that's valid. That seems to be valid as it's currently.
That's my understanding, yes.
Okay. I know you brought up a good question and actually a good point, and I want to remind our audience, we are not talking about rent control type of situations because that is a whole different area of law. But to touch on rent control, I know the law changed and a new law came out as of January 1st, 2020, correct?
That's correct.
What is the new provision for rent control, just to make a global statement, and then I'm going to move on to tenancy.
Gotcha. Well, I'll give a quick update to our viewers. On the Citizens app, there were reports of shots fired at Van Owen and Haskell. So if you're anywhere near Van Owen and Haskell, which if you're watching, you're hopefully indoors anyways, stay indoors. That's probably why the helicopters are buzzing above us.
Yeah.
But the rule that there was a new state law that came into effect as of the 1st. And for rent controlled properties, essentially a property that's 15 years old or more is under the definition of rent control.
Okay.
You cannot, it eliminated what are called no fault eviction. Well, you may say, what's no fault eviction?
Right.
No fault eviction is when the tenant did nothing wrong, meaning the lease term ended, or the landlord wants to move back into the property. The landlord is looking to expand the footprint of the property. In that case, you cannot evict the tenant anymore.
Okay.
So in those scenarios, you're essentially there until the tenant wants to go, or until the tenant violates the term of the lease, non-payment, commits a crime, something along those lines.
Got it. Now, you mentioned a good point, which one of our followers asked the question, and I'm reading it off my phone. They are not in a rent control. Essentially, they're in the La Crescenta, La Cañada area, and their year lease term ends, their tenant's lease term ends at the end of July 31st. They want to go back into their own property and not rent it out anymore. Do they have a right to go back into their property? And if so, what recommendations do you have for them to advise their tenant that they're going to do so?
So the property, you still have to make sure it's not under the rent control provisions of this new state law. If it's a single family home, it most likely is not.
Okay.
There are very limited circumstances. I'm laughing because some of the questions are coming in with multiple question marks, and And some of my friends are popping in. I think someone is coming in from overseas.
That's awesome.
So yeah, I'd have to look at the local rules in La Crescenta, but I have this exact scenario of a unit that is under rent control. It's one part of a duplex. The owner wants to move back in.
Okay.
Well, I know at least now he cannot do that during the pandemic period.
Okay.
You cannot remove that property from the rental market. Now, if you, Stuart, the helicopters are over our house because of shots fired at Van Owen and Haskell. So in that scenario, they want to move back into the house in La Crescenta. They may be prohibited from doing so right now because of the pandemic period. However, they'd have to check with the local jurisdiction and then perhaps the county to see what the protocol is for moving back into the unit. If it's just one property, they're a mom and pop landlord. They don't own more than 4, at least under the Los Angeles rules. If they don't own more than 4 properties, then there is no prohibition. The lease ends, they can give notice of termination.
We are talking about a single residence home in La Cañada, most likely not under rent control. Definitely check your ordinances. But I mean, just to, just to have the landlords back as well, like if the tenant agrees to move and you can do everything cordially, then there's nothing that prevents the landlord, like they're not violating a law just because they want to move back to their property, right?
Right.
Okay, the issue is going to be, which we'll talk about it, is if they don't, and then it's a holdover tenant, meaning you stayed in the property longer than you're supposed to, all the ramifications that are going to come up. So let me read some questions. We have over 70 people viewing, and this is amazing because we are getting a lot of traction, and I'm glad this is helpful. If you guys can share this post, we ask that you do, and we'll have Alex chime in as to his thoughts about what's going on. So yeah, we definitely are getting a lot of people commenting on the sirens and on the helicopters. Somebody said, I can't imagine that the property values are escalating at this time with the economy tanking. Let's see. So Adam chimed in and said it varies from county to county, but it appears LA will be a 12 months. So we have a question. How are people supposed to repay all the rent if they can't afford to pay now? How do landlords expect people to be able to pay? Some people live paycheck to paycheck. And unfortunately, they've been, laid off or getting unemployment, or maybe they aren't able to tap into these resources. Any thoughts?
Right. I do. I don't have a good answer, but I have some thoughts. And I'd mentioned to you, my sister-in-law is apparently there's a structure fire at Van Owen and Haskell too. So stay away from Van Owen and Haskell, structure fire and shots fired. My sister-in-law is a tireless advocate for tenants. She has an organization called Unión de Vecinos, and she's based in Boyle Heights. And that's their main point. We don't want a rent freeze. We want a rent abatement. We want the rent to go away because her community are a lot of individuals who don't make a ton of money. And I think it was Luisa brings up a fantastic point. We can't afford rent now. How are we going to afford 12 months of rent? Well, again, I don't have a good answer. But hopefully there will be relief packages that trickle down. I hate using that term because it reminds everyone of trickle down economics, but hopefully there will be relief packages that come out that help landlords and tenants, because everyone is suffering here. And it's a shame that people point fingers at each other and say, you landlord are at fault, or you tenant are at fault. It's the sign of the times. We're all dealing with tremendous struggle and strife in our own personal and business lives. So hopefully there'll be some sort of package stimulus that allows rent to be perhaps forgiven for a certain amount of time for tenants, but the landlords will then get their fair share so they can pay their mortgage and they can support their own families as well. So
we have to keep in mind these landlords, most of them, or maybe not, but some of them have mortgages they need to pay. And when they're paying these mortgages, or you're not paying your rent, they're not paying their mortgage. Granted, they have some programs in place, but they're getting a ding on their record, right? I mean, is that the understanding of, if you don't pay your mortgage, it will affect your credit? Or do you have any understanding to?
Well, I could tell you what I know based on my own mortgage. I own a single family home with my wife in Van Nuys, as I mentioned. We have a mortgage with JP Morgan Chase. And we looked into, just for our own sake, can we put a pause button on our mortgage payments? And I know for JP Morgan Chase residential lending, at least as it dealt with our particular property, we were able to hit the pause button and would have, I think, 3 months, pause up to 3 months of payments. But late fees would not accrue, but interest would still accrue. And the way we looked at it was, we're blessed to both still be working and not yet have suffered a dramatic impact from this strife and this troubling times we're in. So we decided, let's just pay it. We can pay it because it's not going away. And theoretically, the capitalization of that interest will increase over time. So
Right.
let's say our mortgage is $3,000 a month and we hit pause for 3 months. That's $9,000. There was no penalty to us per se, but our principal balance is now increased by $9,000,
Of course.
and the interest that it capitalizes on top of that. So it was our decision to just keep paying. So everyone needs to check with their own personal lender. They each will have their own rules. And I found, just by going on the main webpage, there'll be information for mortgagees due to COVID-related financial troubles.
Good point, Alex. Somebody's asking, when can, I'm assuming they're a landlord, them give notice to the tenant to pay? Assuming the state of emergency is lifted, is there any recommendations that you may have as to when to, so this, I think landlords are going to be like, okay, you owe me $10,000 for 5 months that you haven't paid, now pay. Is there a rule that dictates as to when they're allowed to give it, or how much time they have to wait?
I'm sorry, the helicopter blew right over my head, right as you gave the punchline of that question.
The question, so hold on.
Right over my head. I'm sorry, give it to me again.
So landlord, residential property or commercial, do they have to wait a certain time until they give notice for payment once the state of emergency is lifted?
That's a good question. And it comes back to, when's that first payment due, right? So I don't know the answer to that, and hopefully there'll be some guidance that we're given by our local government as to what is the protocol, right?
Yeah.
Tenants miss payments. They have, let's stick with the 12 months. They have 12 months to pay. When do they have to start paying the rent that is due? My understanding is the payments that were missed can be paid at any time through that 12 months.
So a lump
up to the tenant.
a combination of, different types of repayment programs. Nothing's set in stone.
Correct. That's my understanding. And I want to touch on one thing. I have a good friend. His name is Adam Cutler. He's in property management. He's on the chat, and he knows this stuff probably better than me. So if you have a question that we're not able to get to or haven't got to yet, Adam will give you an answer. I see him responding to some of the commenters now, and he's someone you could trust and knows a lot about properties, because he deals a lot with commercial and residential properties in his business.
Very nice. So Adam is mentioning you can give notice anytime, but you can't pursue legal action until shelter-in-place order is lifted. Even then, you have to follow the mandates to allow them to repay over time. We're going to get into the legal actions. I want to read some of the questions. We have over 16 comments. Will my rent debt be forgiven when I'll apply for bankruptcy? Well,
I'm not a bankruptcy lawyer, but generally the answer is yes. If you qualify for bankruptcy, your debts are forgiven, assuming they were not incurred through fraudulent means. That would mean rent. That would mean our firm actually used to do a lot of work for creditors, mortgagors who were trying to recover possession of properties after the lender already foreclosed. Meaning you have a mortgage, you didn't pay it for 3 years, the lender forecloses. well, you didn't leave the house. So we would get involved and do what's called post-foreclosure eviction work, because at that point, you have no right of possession.
Right.
But those individuals who, God bless them, they're looking to save their homes. They have no place to go. We get that. We're not Uncle Scrooge over here. We're just enforcing our clients' rights. They would sometimes file bankruptcy to try to maintain possession.
Right.
That's a different question than will my debts be forgiven? But generally, when you file bankruptcy, your debts are forgiven, or they're paid back under a formula that takes into account what you can afford to pay back to all of your creditors.
Right.
Because you probably owe your landlord, your credit card, perhaps some family support payments, and the bills add up, and you can't be expected to get water out of a stone.
Absolutely. And I did have my colleague Karina Karajan last week, we spoke, or the week before, apologies, regarding some bankruptcy questions. So we'll be happy to reach out to her or any one of my other colleagues or your colleagues, Alex. Somebody, Miss Manukian, says landlords buy the properties and then make fake renovations, and then they raise rents for what? If one day all tenants move out from rented apartments, what will the landlords do? Who is going to pay their mortgage and for their luxury cars? We have very bad rent control system. Also, every year without meaning, they increase the rent. Hopefully one day government will give apartments to people who need apartments like Soviet, so these greedy landlords will desperate. That's more of a comment. Let's move on to questions.
Yeah, but focusing on the first part, the question that I took out of that was, a landlord forces me out of the property, they do quote unquote renovations, and then they up the rent to market rate when I was protected by a rent control. Well, at least in Los Angeles, the rent control board is supposed to monitor this stuff and to ensure that you actually are following the rules to remove the property from the market, to basically up rent it, to charge higher rates. So in that case, you report it to the local housing authority, and hopefully the justice will prevail, as they say.
Very nice, Alex. We have over 75, 79 followers. Thank you so much for everybody joining. I know things look really bad outside, and hopefully this could be a good educational and informative diversion. I thank Alex for joining us on a Monday night with helicopters and sirens going on. So I do want to get to questions. We have a lot of questions. Obviously, this is a hot topic. If you're a landlord or a tenant and have questions and don't know your rights, or do know your rights, but it's kind of wobbly, this is the forum. This is the time to ask. Alex is answering almost all the questions that we're going to get through. I'm not even getting to my booklet of questions, but let me continue, Alex. Can't they use Ellis Act that they are taking property out of rental market?
So that's what we talked about before. When an owner wants to move back, and it doesn't have to be the owner, it could be, there are very specific guidelines as to who can move back into a rental unit if you're taking it out of the rental market. It could be the owner, but I believe it could be a spouse, child, grandparent, something like that. The answer is yes, but at least in Los Angeles, which is exactly what one of my clients is dealing with, you cannot do that now. Meaning you want to move back into your duplex that you're renting out and live in one and rent out the other until this emergency period is over. You cannot do that. And I know in Los Angeles, I believe you have to wait at least another 90 or 120 days after the period is over to do that. Now, to remove a property using the Ellis Act, there are time frames. You have to give a certain amount of notice. So one question I have is that I don't know the answer to, but I may look into it for my client, is can you start the process now? Can you give them notice that, hey, in 120 days, I'm going to be moving in back in? The question is, will the housing authority bless that? Because you have to run everything through them. But I would certainly try it, especially in this case, our client can't afford his current place that he's renting. And because of the financial struggles that he's in, he wants to move back in to his place. So it just really shows that it's not just tenants that are suffering. It's property owners, it's individuals who utilize property as investment vehicles to support their lives, their business interests. So it's it's a situation that has to be looked at from all angles. And again, I think back to our main message tonight is, we all need to work together in the real estate market to ensure fairness and equity during these troubling times.
And I know, if you guys see me typing or looking down, I am trying to answer everybody's question or get to it. I know you guys are asking a lot of questions. Please bear with us. We have a lot to go through and a lot of followers. So we will get through all the questions. And if we don't, Alex and I will take the time to respond to it after the feed. So thank you so much for even tuning in, asking the questions, because I'm sure you guys speak volumes for everybody. So we did answer that question. Let me move on. Somebody said plus single family properties are exempt from rent control. Somebody chimed in, or somebody's on disability due to a pandemic. Adam said there is no chance of rent abatement unless they are living in a federally subsidized property. So like you mentioned, Alex, Adam has a good point over there regarding if whether or not it would be forgiven or some type of relief may come towards rent payback.
Adam is generally more pessimistic than I am, but usually with good reason. Okay. He has his eye on the industry trends, and again, his business is real estate. My business is the law that often deals with real estate, but his business is real estate. So, and I tend to agree. I mean, can we really expect, and not to get political, but can we really expect money to flow to people that really need it in the rental market? Based on what we've seen with the PPP loans, where the monies went to businesses, but they also went to a lot of big corporations, I think pessimism is appropriate. So again, it comes back to, well, what's going to happen? Right. But I can see either some legislative or judicial sentiment where, for example, the inability to pay rent during this period, that if you're unable to pay ever because of the time during this period, the courts have said you could use that as what's called an affirmative defense. So if a landlord sues you for possession of property or payments that you missed, and you argue, I just couldn't afford it, and you show proof in the lawsuit, I could see courts reviewing that and perhaps minimizing the amount due. And it's going to be a really interesting landscape at the courts when we all get to go ahead to go back.
You said a key word that I forgot to ask you earlier, proof. Now, I got a lot of questions and a lot of phone calls and a lot of Instagram messages asking me, am I supposed to show proof to my landlord? And I want to break that down to residential and commercial. For those of you who are tuning in, we have a landlord tenant attorney, real estate attorney, who is discussing your rights during COVID, during state of emergency. So thank you for joining us. Feel free to ask questions. I will get through it all. This is probably going to run longer than my usual program because of the topics and the nature of it, but we'll get through it. Proof. Alex, do I, as a resident in a residential property tenant, have to show proof to my landlord that I have lost my job or I can't pay? And is the same answer true as a commercial tenant?
So in the residential setting, at least in Los Angeles, you're not required to provide your landlord proof. There's a form that can be found on the HCIDLA website. That's the housing board for Los Angeles. It's a pre-printed form where you could simply check a box that says why you can't pay rent. But residential tenants do not have to show proof. It's wise to collect proof and have it, because if you get sued, you'll want to demonstrate it in the court of law. Commercial tenants do have to demonstrate proof. I take it back. Commercial tenants don't have to show, they don't have to prove it per se. They have to explain what it is. So what I've been advising my residential tenants is you don't have to give your landlord anything but I'm unable to pay. But a commercial tenant, what we've been doing is, and we're writing letters to the landlord and requesting a rent pause, so to speak. I have the commercial tenant explain why. They're a religious organization. They're unable to receive income for their um, seminars they provide to the public. They normally would charge a $5 fee for a coffee with the pastor, or a bagel with the rabbi, or a talk with the imam, or whatever your religious group is. They generate income from engagement with their community, with their synagogue, with their parish, with their organization. So in that case, when I was helping a religious group, I explained exactly, not dollar for dollar, but we're not having the income from this. We lost the income from that. And that's all you have to do. But going back to the residential, it makes sense to have that proof at the ready. That way, when push comes to shove, you could say, see, this is exactly what I was talking about.
So it's not like I could be working and just tell my landlord as a tenant, residential property, I'm not paying you. It's state of emergency. I don't have the right to pay you. So, or am I allowed to do that?
Under which case again? A residential or commercial?
So let's say there's an individual who's actually working and hasn't lost their job and is completely fine and not affected by COVID, thankfully, but they told their landlord they're not paying them because of COVID.
Well, under the rules in Los Angeles, that's perfectly acceptable. But it comes back to my response about my own personal mortgage. Right. The rent is still due, and you have a job now, but maybe you won't have a job in 3 months. Maybe right. You'll have other expenses within that 12-month repayment period. And so it's really about organizing debts, figuring out what do I have to pay. Right. There are certain debts that we all have to pay. There are certain debts that we can push off.
Right.
But, my father always told me to pay my debts when they come. For many years, I didn't listen to him. And I had terrible debt and terrible credit. And I finally got smart. And now I pay everything on time. I pay it early if I can, and my credit's great. I'm also 45 years old, and I've learned a little bit. And so it's really a question of what can that individual handle financially for their own personal life. If someone can afford to pay, but they choose not to, they have the right to do so. But that rent is still due.
Everybody, the landlords are facing a tough time as well. So if you can do it, you're going to have to do it. Might as well do it and get it over with. We have a comment or a question coming in. Tenant is on a month-to-month at $1,000 per month. If a landlord accepts a lower rent check, partial payment, say $350, will the landlord agree to the $350 per month?
I think what the question is will the landlord waive the $650 remaining going forward? The answer is no, but you waive the right to evict someone for non-payment of rent. So when non-pandemic times,
yeah,
a tenant hasn't paid rent for 9 months, we file an unlawful detainer to gain possession of the property in the back rent. We don't take anything from them anymore, because once you accept rent, you waive your right to possession at that point because you're accepting partial payment.
Even if it's $1?
That's a good question. I would always suggest my client never cash a penny. If not a thing, because you lose your argument to possession. Now,
but there's a key point here. If, let's say, they come into a written agreement that during the pandemic, I will accept $350 as full and final payment, but come the state of emergency being lifted, I will go back to original.
That's a different story. That's a different story.
The landlord is pretty much shooting himself or herself in the foot.
Correct. But maybe a landlord wants to do that. Maybe the landlord, because of their own financial situation, needs at least something up front. And that is often what we'll advise tenants and landlords. You know what? You're in trouble financially. Talk to your landlord, talk to your tenant, work out a resolution that works for both of you, or at least is you can stomach. It may not be great, but at least it's something. Because if going back to what Luzia said before, I'm sorry if I mispronounced her name, if tenants are having trouble now, what are they going to do when 12 months are due or however much time? So if I'm a landlord and I can afford to, I'm going to try to get as much as I can now, but do it properly, not harass a tenant, not threaten a tenant, do it respectfully, do it professionally. And that's, I think, one of the underlying issues. when a tenant rents property, it's their home. It's where they bathe, where they eat, where they meditate, spend time with their children.
Right.
But for a landlord who does it as a business, has multiple properties, this is their business. So each party has to understand that there may be a different perspective as to how this money impacts them, because it's not just money. It's livelihood, it's respect, it's peace, it's things of those nature. So yeah, if a landlord enters into an agreement,
and that's true with or without the pandemic, because, you know, a lot, whether or not we are in a pandemic, it's always nice to have a conversation. And I know that's going to be one of our tips when we end this program, as to what is the best way to resolve it during these times. And as I mentioned earlier in the program, it's nice that you could run to attorneys and we always have your back, but you're going to cough up a lot of, you're going to be in a financial, more of a difficult situation if you think going to an attorney is going to solve your problems. Okay. This is a question that has been asked to me multiple times. I'm gonna address it, and I'm gonna combine a couple of questions together.
Sure.
A landlord keeps messaging and constantly pressuring the tenant to give post-dated checks and stating that, look, just give me a post-dated check. I will cash it when you tell me the money's available. This tenant has been affected, to my understanding, by COVID, lost, it's not working, or has any, whatever the situation may be, is taking care of a child who's going to school from home, homeschooling. So the question is the landlord allowed to ask for post-dated checks? And what can this tenant do from, she believes she's being harassed at this point, to the extent of constant contact, constant reminders, constantly, nagging from the landlord of, when are you going to give me the checks? When are you going to give me the checks?
Right. So to kind of answer all the questions at once, the landlord can't take those measures. The landlord can't harass a tenant during this time period. Bottom line, rent is not due. And I get it. The landlord is under pressure as well. They're getting pressure from their family, from their lender, from their business partners, but they can't go to essentially trying to self-resolve these issues. A post-dated check, it's almost worthless, because who's to say the money is going to be in the account? An argument could be made that it was not validly drafted because it was set for a date in the future. I've seen it done. Back in the day, a tenant gives landlord 12 checks, post-dated, and every month he put them in. And these are different times. Mm-hmm. And ultimately, if a tenant feels they're being harassed by that landlord, what they should do is to go to the local housing authority, go to a local tenants' rights group. There's a fantastic group called the Eviction Defense Network. Elena Pop is a tremendous attorney for tenants, who could provide them guidance, oftentimes without paying an attorney. Because unfortunately, us attorneys, we get expensive, and oftentimes individuals don't have the resources to fight the good fight, so to speak.
Right. And for those of you who are tuning in, we're talking about landlord-tenant rights, and Alex has volunteered his Monday night, and he's following the curfew orders and staying put, and is just divulging years and decades of his knowledge onto what is unprecedented, new times, new ground. My bell's going off, which is the grandfather clock, but this is amazing. Let me see if I could get through all the questions so that we could kind of move on. Let's see, post-date. Adam is definitely saying don't ever have them. They're not supposed to ask for post-dated checks. Also, let me ask you this question, Alex. Everybody's home, or should have been home, and neighbors are also home. And if you're in a townhouse or a condo or an apartment, we could break it down as to apartments first and then condos. Your neighbors are just being loud and annoying and whatnot. Typically, in a regular non-pandemic, not state of the emergency situation, you as an apartment tenant can contact your landlord, and your landlord has to take certain action. Obviously, given the court closures and measures in place, that's not the case. What can you tell our tenants who live in an apartment who do have disturbing neighbors? What remedies, if any, do they have?
That's a tough one, because as you said, under normal circumstances, a landlord is required to provide quiet enjoyment. That was a phrase we used earlier.
Right.
And so forget the pandemic. This is normal times. Tenant 1 is up late every night till 4 a.m. loud parties. Tenant 2 can't sleep. Tenant 2 asks tenant 1 to turn it down. They don't turn it down. Tenant 2 asks the landlord. Well, at that point, the landlord has to take certain steps. The landlord has to do what they can to assist. And the question that will come up is, well, is the landlord required to evict one tenant who is bothering another tenant? And that's a good question. It really depends on the circumstances. It depends on the enormity of the complaint. Because arguably, if someone is up late blasting music, they're creating a nuisance, and that violates the term of the lease. But the landlords, if they're not living on site or don't live in the area, maybe they have one of the units themselves, but if not, they're not going to want to take on the fight. They're likely going to tell Unit 2, this is your problem. Why don't you go get a restraining order against them, which that tenant can do. They can get a restraining order or at least seek one for noise. But I think the better practice is on the landlord is to give the Unit 1 notice that if they don't comply with the lease, that they'll be evicted. Because under that case, they're complying and they're adhering to both leases. They're not ignoring tenant 2 for tenant 1.
Favoritism, yeah. Correct.
And there could be no argument that they didn't respect the tenant's rights who's suffering. So, right. But that's a tough one, and we get that a lot. We represent apartment owners who have tenants that are essentially fighting each other. What do you do? To what extent do you have to be the peacemaker?
Yeah.
Now, well,
you're just a highly paid babysitter at that point,
or a referee or something.
Yeah.
And that's not what a landlord wants to do. They basically want to provide a space and get checks. They want to get paid. The tenant in 2 wants to have quiet enjoyment, which they're entitled to. Now, there is an interesting provision in the current moratorium on evictions, where I don't think we've gotten to this fully yet.
No,
but
we haven't. We're getting right into it. Go ahead.
But I was, and not to get into the introductory part, which we can get into next, but you cannot evict someone for it's. I'm trying to think of the specific language, but it's a nuisance related to COVID-19, meaning once the eviction open back up, which they're not right now, but you can't evict someone because of something related to COVID-19 that may cause a nuisance. Well, what is that? Well, let's say that you have kids at home when they should be at school, right, and they're running around and making noise. Arguably, that's a nuisance. That could be something that you could be evicted for. But if you could say, this is just because of COVID, these kids are home because they have nowhere to go, well, that right to evict would likely go out the window. But in general, you can evict now because courts are not issuing what are called summonses. Summons is what provides the court with jurisdiction over a party.
Right. And so with that, I want to get into the fact that our courts have been closed for a while, notwithstanding like exigent circumstances, criminal matters, domestic violence. So if there was an emergency situation, we were allowed to go to court, but general proceedings were on hold. Criminal trials have been postponed. Unlawful detainers have been postponed. In a typical situation, when you hire an attorney on either end, landlord tenant, they file a complaint, you answer, you get in front of the court, and you get heard. But Alex mentioned a good point. Summons is not being issued. Summons, the legal fancy term for basically having jurisdiction to bring you, to take you from point A to point B and bring you to court. Alex, what is the current climate of the courts as they are opening up today? They weren't open because of all the, the unfortunate situation of everything that's going on in the city of LA. But what is the current standing of if the courts do open up and the state of emergency is lifted? When do you think that landlords will even be presented with the opportunity to get back payment, to evict, and so on and so forth?
right? So in Los Angeles, and I think I have the dates right, but so when you file a lawsuit for unlawful detainer, you go through steps. You have to give notice of the violation, a 3-day, a 30-day, a 60-day, whatever notice provision is required. And if the tenant doesn't comply, at least not to the landlord's satisfaction, they could file an unlawful detainer complaint. And an unlawful detainer complaint is generally to recover possession of the property. And with any complaint in the state of California, when you file the document, you're given what's called a summons back from the court. Or actually, you file it with your document, it gets stamped, and it's returned to you. The summons says you are hereby ordered to appear for this case. And then when you personally serve the complaint in the summons, that party then has 5 days to respond to the complaint.
Wow,
so what the courts
5
are
days.
saying,
So in civil cases, we have
5
30
days.
days from personal
30.
service.
That's correct.
But
That's correct.
UD, unlawful detainer, it's 5 days, right?
5 days normally. But during the pandemic, and I think it's 90 days after the emergency period ends, the courts are not issuing any summonses. So one thing I've read about this that some lawyers are doing is they're mailing complaints to tenants. The tenant doesn't know, they file their answer. Well, guess what? That summons requirement is now at the window because they volunteered themselves to the court. So if you're a tenant.
So let's pause for 1 second. I really want to make this, I really want to hone in on this. I didn't know that. Right now, a landlord cannot get a summons through the court.
Correct.
But if the landlord's attorney tries to outsmart you as a tenant and you do not seek consultation for your rights and you actually get the complaint in the mail and you answer within the 5 days, you have volunteered yourself to be part of that proceeding.
That is my understanding, yes. I mean, that's not typically how my cases go, or I've never had that, but I've read about that, and that makes sense because the idea of a summons is you have to be handed the document because it tells you your rights.
Right.
It tells you that you have a certain amount of time for this and that. But when you file a document and it's signed either by you as a tenant or by your attorney on your behalf, you are agreeing to the court's jurisdiction. You're giving the court the right to adjudicate your issue. So what normally happens, what is going to happen now is you could file an unlawful detainer complaint, but you won't get any summons back from the court. So you have to wait 90 days until after the emergency period is over, then get your summons, and then you could serve it. Now, let's say a tenant unknowingly files an answer. They'll still get some relief because normally you set a trial within 21 days of an answer to a complaint. In this case,
set, right, for UD?
Correct, for 60 days until after the order expires, the emergency order.
Right? Alex, that could change because all these trials, especially the criminal ones, have been postponed. So,
so that's a very good point. The statute, if you forget about the order, the statute says within 21 days, right?
Okay.
So that's not always the case because of the court's congestion. But unlawful detainer complaints are given certain priorities.
Right.
In our new rules, you won't get a trial until 60 days after the order is lifted, but we're going to have criminal cases. We're going to have all sorts of issues with jury trials. Can we have jury trials? I wouldn't expect there to be any unlawful detainer trials for perhaps up to 6 months.
So you mentioned jury trials, and under the Constitution, we have a right to a jury, and that also goes to unlawful detainers, right? Now, I want all the landlords out there, if you know anybody, to hear this very carefully, and also the tenants to know your rights as well. As a tenant, you have a right to request a jury trial, and if you're a tenant's attorney, you're probably doing that, assuming you have good basis. But landlords, I want you to know this, and your attorney should know this, that most landlord attorneys, Alex, right? They would want to waive the jury trial, go to a bench trial, get the matter heard immediately, and call it a day.
That's correct.
Okay. But as a tenant's attorney, you want to have the jury trial, and that is where the unprecedented and uncharted territory is going to come in because of everything that's going on. So what's going to happen? The 21 days could turn into what? A couple of months out?
Well, one of my favorite text emojis is the shrug. We don't know. We run into this a lot when we're representing landlords, that there are some very smart tenant attorneys out there who know how to delay the process. They oftentimes, when you go for a unlawful detainer trial, you're met with what's called a commissioner. And you have to sign a document that says that I'm authorizing the commissioner to hear my case.
Okay.
Well, a tenant's attorney may say, no, I'm not going to agree to that. I want a judge. Well, oftentimes that means you have to wait because there are oftentimes not enough judges to hear all the unlawful detainer trials that are happening on any given day.
Stamp is right underneath the name. Even though somebody's sitting behind the bench in a courtroom does not necessarily mean that they're the judge, correct? So commissioner and judge, two different things.
Two different things. They both can make rulings.
Okay.
But it will say on their nameplate, Commissioner Kasendorf, Commissioner Malyan. It won't say judge this or judge that. And a commissioner, you always have to sign a form before you're heard by that commissioner, authorizing that commissioner to hear your case.
Very
so
nice.
Back to the issue with juries.
Okay.
We talked about this offline the other day. Can we really expect hundreds of people to congregate in a juror room to handle all the jury trial requests? But we're constitutionally protected and guaranteed the right to a jury trial. So what's going to happen there? Are there going to be new rules that come out? Are there going to be lawsuits about these new rules? I
think we're going to see a lot of changes within the next 2 to 3 weeks. This is just my thoughts. I don't stand, and I'm not making a health or public announcement or taking a position, but we have all these protests going on with thousands and thousands of people congregated in one area. And with the health and safety rules that are coming out, why we should social distance and stay away because of the spread, we'll kind of see where it stands. And maybe that might tailor it or give us precedent as to, can we bring the jury? But the courts are going to do, our presiding judge has taken, steps to ensure that we are safe and that the courtroom staff is safe, and we take the measures, right? So we are living in interesting times. So things change daily. But you're absolutely right, Alex. We don't know if we're going to be faced with putting off juries or having jury trials. And I know a couple of the states had started testing the Zoom, and psychologists got involved on the meaningful effect with in person versus Zoom. So who knows?
Who knows?
Yeah, who knows? Let me see if I can get to some questions here. Let's see. If you can read into, is the noise nuisance considered a public safety risk?
A noise complaint, is it a public safety risk? Likely, typically not. What they may be referring to is, we talked about not being able to get a summons issued. That's not absolute. If the tenant is doing something that potentially harms the health and safety of another individual of themselves, then you can apply to the court on what's called an ex parte basis, which means you give notice to the other party by 10 a.m. the day before, I'm going to court. And when I say go, you're probably going to call in on what's called court call. You're going to do a telephonic appearance at this point, and you're going to ask the court to allow a summons to be issued because it's unrelated to COVID, it's unrelated to non-payment, it's related to the health and safety of an individual. And I know some attorneys have been successful in getting a summons issued. So a noise nuisance is likely not that, unless they're, I guess there could be a scenario where extremely loud noise could be harmful to the public health, to the mental well-being of other individuals. But typically, just because a neighbor is being loud, that will likely not get you into court on the unlawful detainer until we get out of the emergency period.
Okay. Somebody asked, can you talk a little bit more about managers, landlords entering a tenant's apartment without proper notice? More than 2 tenants have complained to the manager and they have no way of contacting the owners.
Well, typically a owner of an apartment and their manager or a vendor on their behalf, a contractor, you have to give, it will say in the lease what kind of notice, but I can't imagine it's less than 24 hours, 48 hours, or reasonable notice. And if a landlord is barging in, they're breaching your quiet enjoyment.
Right.
And arguably they are
situation, right? Let's say fire,
correct.
gas leak, plumbing.
Water, yes, exactly.
Okay.
So if the landlord keeps coming in, well, you probably need to get either a local housing authority involved, perhaps an attorney to inform them that this has to stop or they'll be held liable for damages. It's a breach of the lease.
Okay. We have a funny question. I don't know if you want to answer, but I'm going to read it just to get this mood livelier. Here's a crazy question. If a tenant is always naked on the first floor with their blinds always open where people can see them, is that considered indecent exposure?
Robin, what's the address? I think we need to investigate this further. No, I'm kidding. It's a joke. Well, indecent exposure is a criminal violation. It's a penal code violation. It's more likely a public nuisance. So
that's
always. I'm just looking back at the question. Is they always naked on the first? The blinds always open. Yeah, I mean they are. Can you get in front of court now? No, but it certainly is a breach of the lease. I would think a breach of the lease under normal times. Yeah, you can't expose yourself to the public. It's a nuisance, and it's likely grounds to evict you from the property.
Very nice. And final question that came through my Instagram, and you can find all my handles. I'm Malyan Law, whether it's Facebook, Instagram, my YouTube channel, which I upload all these videos. Can a landlord join in the lawsuit that has been filed against the mayor? I know we touched upon this, but I want you to mention it for our audience.
Robin wants to know, though, first, how we make that stop. Well, that's a good question. I think the landlord has to notify that tenant that what they're doing is violating the lease, and that if it continues, that she'll be held liable for that and she'll be removed from the property.
Okay.
Perhaps, I don't know. That's a tough one. That's a tough one.
We talked about, you mentioned something about the fact that if you're in an apartment complex, you can give notice. The landlord could start taking care of some of the nuisance that is prevalent, but they can't really do any evictions or until the court's open. But if you are a owner of a townhouse or a condominium and your neighbor is also being obnoxious and, you know, just not respecting your rights, playing loud music, you know, because of the quarantine, there are some civil remedies, right? With regards to calling cops. What are your thoughts about that?
Yeah, I mean, I would notify the police because it's likely is a penal code violation. By exposing yourself to the public, you are committing a crime. Start there and, you know, move backwards, because anytime you want to file a civil action, you're then paying money for a lawyer. You may or may not be able to recover your attorney's fees. So the first order of business typically would be the local police authority.
Okay.
And then remind me again the question that
The landlord question. Can a landlord?
Oh yeah, the lawsuit.
The lawsuit against the mayor.
Yeah. Well, this is what I know. There's an attorney and who does a lot of landlord work. I don't know him personally, and I won't mention his name because it's not relevant. But my understanding is he's filed a lawsuit against the government, against the state, basically saying what you're doing by prohibiting the landlords from doing these unlawful detainers violates their constitutional rights.
Right.
So the question is, can someone who's a landlord say, yeah, that's me, I want in on this? There's a possibility. They can join as what's called a third-party intervener. They'd have to demonstrate to the court that they have the same rights that are being violated. But they should probably call that person who's filing a lawsuit, because if they're successful and the rules are changed, then that landlord will be able to take advantage of the change in rules. I suspect that the lawsuit will not be successful or even get very far, because we're under emergency orders and the government is allowed to take widespread action in the time of crisis.
Mhm. And just to, I know we've taken everybody's time. This is the longest program I've had for obvious reasons. There's a lot to discuss, but I think we've covered residential landlord rights. We've covered commercial landlord rights. We've covered on the other side of the spectrum what tenants' rights are for commercial, or what they can expect, and what residential are. But to kind of summarize everything without going into further detail, I want to hone in on a couple of points, Alex. I want us to be able to tell the public what measures and mitigating factors can we all do in order to avoid heartache, avoid frustration, avoid financial hardship. Hiring an attorney like yourself is not going to be cheap, or anywhere in any situation. So I kind of want to see what we can offer our tenants, what they can do, and our landlords to work with our tenants.
Sure. I mean, I think that the key is communication. I mean, it's said all the time in various aspects of our lives. You got to talk to the other side. You got to talk to your tenant. You got to talk to your landlord. And you have to know your rights. You have to know the rules. Because if you don't know what the rules are in place that may be protecting you, you go into the battle without a loaded weapon. You really are without the ability to understand what you're entitled to as a landlord, as a tenant, as a neighbor. You need to know what your rights are. And then you go into the situation understanding what you could expect to get out of it, and explain the issue, talk about it, and emphasize the fact that no one's getting anywhere with lawyers right now. They really aren't. I mean, we as lawyers still have our cases, we still have our matters, and we're advocating for our clients, but we're not getting any results. The only way we're getting a result in a case or a resolution of a case is if we settle it. And that takes two sides. That takes both parties to understand that, you know what, it may not be the best, but it's something that I can be in control of right now, and a result that I can get some sort of success right now. So communication, negotiation, and open-mindedness.
And one other thing, I know we talked about it, that those are great points, Alex. If you can actually negotiate with your landlord to come to a happy medium where you're paying something into the rent and they're accepting it as full and final payment, I think both parties, look, in mediation, neither party is ever happy, neither party ever thinks they win, and neither party thinks that, you know, the other party won. It's a loss or a win-win depending on which stance you take. But if you have the opportunity to talk to your clients, to talk to your tenants, or to talk to your landlords and come to a resolution, I think everybody's going to be happy. With that said, we're always happy to take on clients, to represent them, but things can be done without attorneys sometimes. And the key is to communicate. Final question, I think is a very important question, and we're going to end it on that note, given the time. And Alex does have a family to attend to, so I do thank him for his time, giving us an hour and a half of his super knowledge. Final question, can your landlord, I'm going to summarize it, actually have you agree to a non-jury trial and enter into a bench trial? Essentially, can you waive your jury trial requirement?
That's a good question. And I know I've seen that, waiving rights to jury, waiving rights to litigation. You got to go to arbitration, et cetera, et cetera. You know what? I got to be honest. I don't know the specific answer to that. I'd have to look at case law that talks about waiver of jury trial, because there's two ends of that argument. One, we're entitled to jury trial as citizens of the United States of America. Two, contracting parties can waive certain rights, but certain rights are unwaivable. They call them unalienable. So my gut is that you can enter into an agreement that dictates how the agreement shall be enforced, as long as it's signed in good faith and it is clear. I think Adam left.
There are those rights under the Constitution. And civil matters, we could do jury trials, but like attorneys can, request.
They could be waived, right?
Waive, but those are civil matters. But you're talking about tenancy, and you're talking about. I tagged Adam. Maybe he would know. So hopefully he'll give us an answer, and both of us will know. essentially, I do want to wrap it up. I do want to close it off by, within the next couple of minutes for 8:30.
So I got an answer. So my colleague just texted me, who I do a lot of work with, David Alvarez.
Yes.
He's a partner of my firm. He actually is kind of my real estate guru. His thought is that you cannot waive a jury trial in a lease. So even if there is a provision that says I waive jury, you can still get a jury.
Okay, that's good to know. Definitely, if you have any situations, reach out to an attorney. I do want to wrap it up. Today's program was extensive, a lot, but bottom line is, if you can pay your rent, pay it. It's going to be due. It doesn't matter if you're in residential or commercial. Avoid going to an attorney. They're going to rack up your costs. They're going to charge you an arm and a leg, and you're still going to end up paying it. All the attorney is going to do is, talk to the other side when you can talk to the other side. If you cannot pay it, you're not required to pay it during the state of emergency. Alex, correct me if I'm wrong with any of the statements I made. With that said, be patient. If you guys need any of our assistance, we're always here to help. I know Alex's phone has been ringing off the hook, and he's been providing just consultations over the phone and easing people's concerns. Residential or commercial landlords, residential or commercial tenants, you guys have rights, and we are here to provide that knowledge to you. I do want to thank you for your time. You can always contact my law firm, and I will put you in touch with the right attorneys who can provide guidance. If you don't have an answer, or if you don't know an answer to a question before making a move, please call my office. And just today, I had referred Alex 3 people just to call and consult with him and give some guidance. But with that said, I want to thank everybody. Please stay safe. I know a lot is going on. We are, all of us are in this together. And with these programs, my goal has been always to provide some information, some, general advice, so that you know where you stand and what can happen in those situations. My next program, as I mentioned earlier, is I'm going to try to get an agent out to talk about the business losses and insurance claims relating to all the looting, all the riots, all the fires and vandalism that is taking place. And in addition to building insurance, because those two differ, including with that, the personal property that is being destroyed, stolen, and taken away from these owners. I know we're facing hard times, but I do thank everybody. I wish everybody well. Alex, thank you so much. It's been a wonderful 90 minutes, and I don't know how this 90 minutes flew by, but it sure did. And I just want to thank you, and hope everybody at your firm and loved ones are safe and healthy.
My absolute pleasure. Thank you very much for having me.
Thank you, everybody. I am logging off from Facebook. Thank you for joining us. We will be in touch.